Call the first matter, calendar this morning, Tony Webster versus Hennepin County. Mr. Flaherty, you've reserved 15 minutes for rebuttal. Do want to note for the record that the Chief Justice is not available today, but will be participating in the decision and outcome of this case. Mr. Flaherty, if you're ready to proceed, you may do so.
Thank you, Your Honor. May it please the court. The three issues raised, Scott Flaherty representing appellant Tony Webster. The three issues raised in this appeal can be resolved through resort to just two well-settled legal principles in this court's precedent. The first two issues can and ought to be disposed of based on the deferential standard of review that applies to a fact finder's fact-finding. And the third issue can be resolved by the plain language analysis that this court applies to statutes here regarding the meaning of the term request. What frames all three issues before the court today is in part what is not at issue in this appeal. Hennepin County does not appeal the findings that the ALJ made regarding the violations of certain violations of Chapter 13. Hennepin County does not appeal the timeliness violation of Section 1303, specifically the ALJ's finding that the 19-week delay was unreasonable. Hennepin County likewise does not appeal that it engaged in improper redactions. And Hennepin County does not appeal that it failed to provide a basis for those redactions in writing as the statute requires. Now,
Counsel, I'd like to go to page 22 of the Hennepin County's brief, because one of the issues that we have to talk about here is the existence of procedures. And this seems to be the best description, at least in my opinion, of their position. They claim these four items that appear on page 22 are evidence of procedures. I'm particularly concerned about the so-called data access policy and the internal policies to track data requests. Are those or are those not procedures?
Those are not procedures compliant with Chapter 13. There are some policies that Hennepin has in this record. That is true. But procedures alone are not enough, and the ALJ properly recognized that. The statute requires more than the existence of procedures. Section 1303, subdivision 2A, requires a governmental entity to establish procedures, and those procedures have at least three aspects. One, the procedures must be consistent with this chapter, that's Chapter 13. Second, the procedures must ensure that requests are received in a prompt and appropriate manner and complied with in a prompt and appropriate manner. So the fact that there are some policies in this record does not mean that the ALJ clearly erred in finding that Hennepin's procedures didn't comply with Section 1303.
And why is the Court of Appeals wrong when it said that you can't, when Hennepin County gets 500 requests a month, and that's in the record, I believe, you can't take a look at one to see whether the procedures are established or not?
So there's a couple of responses to that. One comes from the written direct of Hennepin County's responsible authority. At page 3 of Lottie Johnson's written direct, she admits that the vast majority of requests that come to Hennepin County don't even cross her desk. She doesn't know what happens with those. She doesn't track them. And she could not have put procedures into place to ensure that compliance is prompt and appropriate if she's not even tracking them. And the Court of Appeals, to an extent there, was asking the wrong question. I want to be clear about an important point here. Not every violation of timeliness or the redaction requirements of Section 1303 necessarily gives rise to a procedural violation. A county can and should have the opportunity to show a fact finder, we have procedures in place, but they happened not to be followed here. If such an argument had been made, this would be a very different appeal. That's not the argument Hennepin County is making here. Hennepin broke the law and didn't appeal most of that law breaking, and nonetheless wants its procedures to be held adequate. That's a problem. This record shows some of the problems with Hennepin's procedures predated Webster's request. They were revealed by the request, but they were not caused by it.
But counsel, following up on Justice Chudich's question, what I hear you saying is essentially Hennepin County, a big place, decided to adopt a decentralized data practices procedure where they have multiple responsible authorities. What on its face is wrong with that? I mean, you could conceivably have a decentralized system that works in a slam-bang manner.
You could have such a system, Your Honor. That's absolutely correct. So the problem here is not that the system was decentralized. The problem is that the statute imposes a responsibility on Hennepin County to ensure that requests are complied with both in an appropriate and prompt manner. So the decentralization is not the problem here. The lack of compliance is. Hennepin County can't know that it's complying promptly with requests if its responsible authority isn't even tracking them. And she admitted the ALJ found, paragraph 2 of its findings, that the vast majority of requests that came in simply bypassed the responsible authority. And that's why I want to reiterate the point that what is not being argued here by Hennepin, this isn't a case where a policy was not followed and that led to a Chapter 13 violation. Hennepin County is defending the policy that led to these violations. These violations should not happen again. The 19 weeks is unreasonable and that's not challenged on appeal. The improper redactions, illegal, not challenged on appeal. But nonetheless.
But counsel, what would be the cutoff if you're looking at bookends? Is 2 weeks, is that too long? 3 weeks, 4 weeks? I mean, tell me what are the bookends as far as what you define as prompt?
Well, so because promptness is a general term, it's necessarily a factual question. And the answer might be different for a wealthy county with state-of-the-art technology, for Hennepin as opposed to a more rural county like Cass County. But promptness refers to when production commences. So in a larger request, such as the one in this case, a county may need more time to finish compliance. And this case isn't about the length of time it took Hennepin to complete its compliance, which is still not yet complete. But it didn't commence compliance until 2 weeks. So to answer your question, if I had to give a specific date restriction, the relevant IPAD opinions 96-006 refers to 13 weeks as a clear violation and refers to a 10-week delay as a violation. So if we're looking for a bright line rule as a matter of law of what's a violation, 10 weeks is certainly too much according to the IPAD opinions, and those are supposed to be given deference by a court. But our view is that it necessitates.
Oh, sorry.
Go ahead.
But didn't your client kind of complicate matters by submitting questions that really Hennepin County didn't have a duty to answer under the law, but undertook the time to do? I mean, it'd be a different thing if he had only submitted the 2 requests for, or I think it was 1 through 3 and 14, and not all the middle part.
Well, the ALJ rejected that argument as a factual matter, finding that when the county complained that its delay in producing data was due to answering those questions, the ALJ described that as gratuitous. And consistent with what the Court of Appeals kind of suggested, my client began this process hoping for something that would be interactive and a give and take. The record is replete with my client's efforts to compromise, to help them out. There's the November 2nd phone call where my client tries to find out what they're doing and offers to reduce their burden, and the designee at Hennepin County is sort of cagey and doesn't say who's working on it or what they're doing. So I don't think it's a wise rule to bar requesters from asking these types of questions. But I think this inquiry frames it a little inconsistently with the statute. The obligation the statute puts on governmental entities is to comply with requests. So where a request is coupled with questions, whether or not the entity answers the questions, it has to obey the law, and the law requires the production of data. So based on the ALJ's findings, we think it would be inconsistent with the standard of review to find that my client was at fault for asking questions. That's not consistent with what the ALJ found. And certainly there's nothing in the text of Chapter 13 that excuses noncompliance where a request is coupled with questions. I'm aware of no such authority holding that.
So I want to go back to the very first question I asked you, which is dealing with the data access policy. So if I understand your response, at least in part, it is that we look to the 3A violation because of the delays and say because there are these long list of failures in terms of timeliness, that tells us that there aren't procedures that ensure an appropriate response. Is that a summary of kind of your position?
It's a fair summary, Your Honor, that the timeliness violations and the redaction violations are some evidence of the lack of procedures. this isn't a summary judgment appeal, but you can imagine if it was, where a requester comes forth with some evidence that Chapter 13 was violated, and then the other party ought to be allowed to show that the violation was not caused by a procedural defect, but a one-off or a failure to follow the policy. That, again, would be a very different case. But not every violation not every timeliness violation necessarily entails a procedural one. What makes this case unusual is that Hennepin County has not challenged the other violations, but nonetheless tries to defend its procedures. Now, the problem with the procedures are not that they're decentralized or not that there is no web page that they can point to that couldn't be considered some sort of policy. The question is more general, and the ALJ reflected this in considering all the evidence and rejecting that whatever procedures are in place, if a web page can be called a procedure, don't ensure prompt and appropriate compliance, and that's what the statute requires. So whether procedures are good enough is truly a functional one. It's not consistent with the statute to look at procedures in a vacuum or to read a document in a vacuum. The statute says that the procedures must ensure that requests for data are complied with. So it's a functional test, kind of the proof is in the pudding, if you will. And in fact, the record before the ALJ revealed a lot of the procedural problems here. I already mentioned that the vast majority of requests bypass the responsible authority. Page 17 of
But counsel, why is that so unusual with a county the size of Hennepin? I mean, clearly you have one person who's overseeing all of that, but I mean, the record does indicate that there are other people who are responsible for tracking, that there is a tracking system. It may not actually be done by Christy Lottie Johnson, but that there are others who are involved in that process. And only perhaps when an issue is elevated to the top does she become involved. So what's wrong with that? If they have an internal system the size of Hennepin County, you'd have to have more than one person involved.
The presence of a system alone is not sufficient. The system must ensure prompt compliance. And that didn't happen here. And the ALJ didn't find, and I can't explain, how a system can ensure prompt compliance where the head of the system is not tracking the promptness, and where, in this case, where the head of that system is involved, and there's a gross violation of prompt compliance. 19 weeks is well beyond what the relevant IPAD opinions say is a clear violation. So the fact of decentralization, not a problem. And maybe in some other situations, the fact that the requests don't go to the responsible authority also wouldn't be a problem. But where there is a timeliness violation and the responsible authority didn't testify to any sort of procedure of tracking promptness, that's a procedural problem. And it would be a very different case if ordinarily someone is tracking the promptness, but that ball was dropped here or that procedure wasn't followed in this case. No evidence like that is in this record. Hennepin is not arguing that this was a one-off and normally their compliance is prompt. There's no record before the ALJ that Lottie Johnson is tracking promptness at all. And the statute requires prompt compliance. And in fact, the ALJ found that Lottie Johnson chose to delay in order to answer the questions and ran its second search, this is on page 17 of Hennepin County's brief, in order to show Webster the undue burden that his request had caused. That's radically inconsistent with a statute that requires prompt compliance. Whether or not the questions are answered, or whether or not a county wants to engage in additional activities to show the burden or to work with a requester to narrow it, compliance is what's required, and additional choices by the county don't excuse that violation of the law. That's what this is about, and that's what the ALJ properly recognized. Also, the one mistake the Court of Appeals made was not viewing the record in a light most favorable to Webster. The record here reveals a pattern of stonewalling by the county. 6 or 7 times the county sent Webster requests sent Webster responses saying your request is being processed. And whether that was literally false or not, it was certainly misleading. The ALJ found that Hennepin County did less than a day's worth of work to respond to request 14 over a multi-week period. And in response, Webster continues to be patient and polite and over offers to reduce the scope of his search, and in fact does. And at one point in response, the county wants additional narrower keywords. the record here reveals something other than prompt compliance. And we could argue about what that is, and the ALJ didn't find bad faith, although it seemed to find something more akin to negligence, although it didn't use that word. But whatever happened here, prompt compliance didn't. And there's no argument being made here that the absence of prompt compliance was caused by deviation from an otherwise good policy. The defense being run by Hennepin County here is that they broke the law, but their policy is good enough anyway. That's deeply counterintuitive, and that's not consistent with the text of the statute.
Counsel, let me move to your issue 3. I'm a little unclear whether we even have jurisdiction over that, because you won on that point, and you are the one petitioning on it, and usually that doesn't get you jurisdiction in this court.
Well, so unlike with a notice of appeal, Rule 117 allows this court to grant review on an issue where a party prevailed. So in terms of jurisdiction, it is present. And apart from the Rule 117, the language in the Court of Appeals decision, even though it nominally affirmed the ALJ's order, it has some problematic language that suggests that a responsible authority can engage in a relevancy determination when producing responsive data. And that places Webster, perhaps, depending on a reading of the Court of Appeals opinion, perhaps Webster might be aggrieved on remand. Our subjective concern was that even though Webster identified the data in item 14 very specifically by keyword, if on remand, Hennepin County is able to determine for itself what it believes is or is not relevant, that's a problem, and that would result him getting a subset of the data he actually sought.
But
and identified.
you could appeal that then, I mean, when the adverse ruling is made. I mean, I guess what you're saying kind of, to me, violates the fundamental principle that you can't win below, but then appeal and say, you know, I didn't really like the reasoning below. I'd rather have a different opinion that says something else. What's your response to that?
Both this court and the U.S. Supreme Court recognize the exceptional role of apex courts in developing the law, and this question was important, and that's part of the reason we raised it in the PFR, even though we prevailed both in the district court and the Court of Appeals. So I do agree that on remand, if there were a problem with the relevancy determination, that would be appealable. But on the other hand, this question is important. It is within this case. And so there's both jurisdiction, and I think the court was proper to grant review on that issue. And it was on that issue that Hennepin County itself urged this court to review in its response to the PFR. So even if the court has some lingering doubts as to jurisdictional mootness or standing issues on issue 3, the county's response to Webster's PFR can fairly be read as a cross petition on that issue. And certainly Hennepin County was aggrieved on issue 3 because it lost that issue both in front of the ALJ and the Court of Appeals.
Counsel, let me understand what the rule of law is then that you would request on issue 3. Is the rule of law that the Data Practices Act does not preclude a requester from identifying data sought by keyword?
That is correct, Your Honor.
Well, at page 48 of your brief, your caption is, the Court of Appeals correctly recognized that the Data Practices Act does not preclude a requester from identifying data sought by keyword.
Then that's true.
So you want us to say, yep, the Court of Appeals was right about that?
As to that narrow point, yes, absolutely. And we are asking this court to affirm the Court of Appeals on issue 3. We do not want it to adopt the rule of law or one rule of law that appears to emerge from the Court of Appeals opinion, which is this notion of freestanding relevancy determinations that may be made in response to a request. That's inconsistent with Chapter 13 and creates some problems. And it doesn't make sense where a requester need not identify himself nor his reason for requesting data. So the portion of the Court of Appeals that we would like this court to affirm is its affirmance of the ALJ. The portion we would like this court to reject is a notion of a freewheeling relevancy determination that could be made once a requester identifies data.
Well, if there was that freewheeling comment in the Court of Appeals opinion, wouldn't that be dictum?
It very might well be, Your Honor. In fact, our primary argument on remand would be that this is dictum. But I've
So you're asking us to clean up the Court of Appeals dictum?
Yes, Your Honor, and in fact, as we explained in our petition for review, this is an issue of first impression, and where the Court of Appeals rules on issues of first impression, even in unpublished decision, district courts have a pattern of following that and treating it as law. So even though it is dictum, because on this point there is no other law out there, we can and should expect it to be followed.
And this was an unpublished opinion from the Court of Appeals
That's correct, Your Honor.
containing discussion of issues of first impression?
Yes, Your Honor. In spite of both parties agreeing that this was an issue of first impression, as well as the high stack of amicus briefs. So this is an important issue, and I see that my time has expired, so I will reserve 15 minutes for rebuttal. Thank you.
You did a better job of watching the clock than I did. Thank you. Mr. Rogan?
May it please the court. I'm Dan Rogan. I'm representing Hennepin County and the Hennepin County Sheriff's Office in this matter. We are asking the court to affirm two legal rulings from the Court of Appeals and hold that Hennepin County's data practices procedures did not violate 13.03 subdivision 2, and our email system stores data in a way that does not store data in a way that violates 13.03 subdivision 1.
Counsel, regarding the procedures argument, how do you respond to counsel's argument that Hennepin County never argued that this was just a one-time failure of procedures?
Your Honor, we did argue that. What we have argued to the ALJ and what we argued to the Court of Appeals was that we have procedures that comply with the statute that were articulated by Justice Anderson that are in our brief that outline exactly how we track data practices requests. And as the court previously mentioned, we are a big county, so we have a decentralized system. Most of the requests don't come to one person. They actually go to the department where the data exists, and they're complied with in that fashion. That wasn't what was at issue in this case. What was at issue in this case was a broad request that did come to Ms. Lottie Johnson. And the procedures that are articulated in in the record before the ALJ and in the ALJ's decision show that we do have a procedure to comply with data practices requests. What we didn't appeal, as Mr. Flaherty pointed out, was in this case, the ALJ made factual findings that our length of time in responding to Mr. Webster's request was too long. That's a violation of 13.03 subdivision 3, not subdivision 2, a procedural violation. It's a violation of whether or not we responded in a reasonable amount of time. We argued before the ALJ that in light of the breadth of his request and the questions that he asked, that it was reasonable, but he ruled against us on that, and based on his factual findings, we chose not to appeal that issue, but did appeal the question of whether or not there were procedures that we have that violated the statute.
Let's leave aside the timeliness question for just a second, but move on to the other point, which is policies and procedures. My understanding of the record is that Hennepin County did not update their written policies on the website until after this litigation began. And so I'm wondering why the absence of updated policies doesn't support the ALJ's conclusion by itself.
There's two responses to that, Your Honor. First is, to the extent that there was a violation of the data access policy, that would be a violation of 13.025, which was not argued by Mr. Webster. But second, and more importantly, as articulated in our brief, we actually did update the policy. The policy was updated in May of 2014 when Ms. Lottie Johnson became the responsible authority, so it identified the correct person, and it was subsequently updated later to reflect a change in the responsible authority at the sheriff's office. So in fact, the factual record supports our argument that the policy was up to date, but more importantly, that the data access policy question was not one that Mr. Webster articulated as a basis for his complaint to the ALJ.
Counsel, if I may.
I want to talk about the, one of these points that you raised on page 22 of your brief, one of these documents that you cite, and I'm looking at the second one here, created and published and updated a data access policy. So I went to Exhibit 43, and it seems like the last 3 pages are the pages that are relevant to what you're claiming here. And I have to say, there is nothing here. I mean, there's a lot of discussion about you contact this person and so forth and so on. And the only procedure, that discussion that I see here is a paragraph that says when the county receives your request, it works to process that request. If the county does not have the data or the data is not public, county officials will notify you. State law does not require the county to collect new data in response to a data request. I don't even find in these 3 pages under this open government policy a policy or procedure of the county that requests will be timely handled even. Now, there is a statutory reference. You can go look up the statute, and I suppose you could say it's included by implication, but that sure doesn't look like much of a policy or procedure to me. Tell me why I'm wrong about that.
Your Honor, the data access policy is Hennepin County's compliance with 13.025, which requires a data access policy that tells the public about how they can access data and what we will do when we get those requests. The procedures, and it's unclear exactly what procedures Mr. Webster was claiming was improper other than the delay in this, don't have to be written down. And in fact, in Hennepin County, they're not written down. Ms. Lottie Johnson, as described on page 22, and the record shows, has a procedure to, once we get a request and that comes to her that she's responsible for, that she delegates it to people to respond to, and then that she tracks it so that she can update the requester. So the procedures are those that were articulated in the record and are not reliant solely on the data access policy.
Well, all I'm saying here is that your brief tells me on page 22, these are the 4 things you want us to look at. This is one of those 4 things, and it doesn't say anything about procedure. I mean, or at least that's a reasonable way to read the policy, I think.
Your Honor, I think that in part the procedures are to ensure that requests for government data are received. That's one of the parts. This helps us make sure that they are received by the proper person. They tell the public where to send them, how to send them, so that we can receive them. The procedures on the internal part of Hennepin County are led by Ms. Lottie Johnson, and she has procedures that are set up to make sure that those requests are complied with in a prompt manner.
And where in the record? So are you telling me that I can go to her testimony in the record and I will find her outlining exactly what those procedures are?
Yes, Your Honor, they are exactly as described on page 22 of my brief. That her testimony describes exactly how she deals with those types of requests and what her procedures are for ensuring compliance with that.
Counsel, does Ms. Lottie Johnson's unwritten procedures include when she sends a request to another part of the Hennepin County, giving them a deadline or a timeline on when they're supposed to respond?
There's nothing in the record on explicitly stating that Ms. Lottie Johnson has a procedure to describe exactly when somebody has to respond.
Isn't that pretty fundamental? I mean, if you've really got somebody in charge of data practices, even if it's a decentralized system, isn't there some obligation, if you're going to ensure promptness, to give the downstream person some kind of timeline on when to respond?
Your Honor, yes, there is, but I don't think it has to be in a written procedure that Ms. Lottie Johnson has.
Well, how about an unwritten procedure? Does she have such an unwritten procedure, or does the record just not tell us?
The record doesn't tell us, but yes, Your Honor, she does have a procedure. As I described before, she has a staff member who tracks each one of these requests, and they meet weekly to get an update on it.
I'm not talking about tracking, I'm talking about deadlines.
Right, Your Honor, and the reason that they're meeting weekly is so that they can get an update on where we are on responding to it, which implies that the record doesn't reflect that she tells people a deadline, but the implication is that I have told you to get this data so that I can respond to it, and that she has. It's not in the record that she always.
Well, I'm not sure you can imply from the idea that they're going to check in every week that that's a deadline to get something done. I mean, a bureaucrat may say, well, I'm getting my weekly call, and I'm not doing anything about it, and nothing's going to happen to me. I mean, doesn't a procedure to ensure promptness at least require some sort of internal deadline?
I think it does, Your Honor. I don't think that the record reflects that Ms. Lottie Johnson testified that she always gives an internal deadline to requesters, and that instead it's an iterative process.
Does it reflect that she ever gives a deadline?
I don't believe the record reflects a deadline. I don't believe it reflects a discussion about this specific topic about when you delegate something to somebody, what parameters do you put on it? The record doesn't reflect that one way or the other, Your Honor.
Counsel, my question really is a follow-up, I think, to Justice Anderson's question. and you may have answered it already, there were no, and that is, were there any written policies whatsoever? I'm hearing you say that's not required, but did the county submit any to the ALJ, anything in writing concerning any of its policies or procedures?
Your Honor, the only policy that was part of the record was the data access policy. That's part of the record that Justice Anderson read from earlier.
So that short description that he was reading that says it doesn't tell him very much, that's the only thing that was submitted?
Well, that's my opinion. I suspect
sorry
he doesn't,
about that.
I suspect he doesn't agree with that. But that's the 3 pages that are attached to
Okay,
the
I just want to make
open
sure we're
government.
talking about the same document. That's what we're talking about.
Yes, Your Honor, and I would quibble with whether it's short or
I
not.
assume
but
you would. I assume
It's
you
part of
would.
an open government policy or policy that explains a number of different things, including how to make requests in Hennepin County and what we will do to respond to those requests and whether you have to pay or not. So it has more information in it than just what the part that Justice Anderson read.
Counsel,
Where would
how
we find
does
that? Where would we find that? Excuse me, Justice Chudich. Where would we find that?
It's part of Exhibit 43 to Mr. Webster's exhibit, which is the portion that I have put in the addendum is at page 47 of my addendum.
And Counsel, how does Hennepin County's website fit into any of this?
Your Honor, it fits in because the data access policy is required by 13.025 to have it on the website, and so that's how that's why the data access policy exists on the website. Is it's mandated by statute to do so. Your Honor, I'd like to move to the third issue that is here, that the question of whether or not Mr. Webster's term search demand is a request for public data.
I guess the first question is it here? And I noticed that the county didn't seek review on the Court of Appeals decision in that regard. Now we've got the appellant saying the Court of Appeals is correct. We've got the respondent saying the Court of Appeals is incorrect. What's that all about?
Your Honor, I do believe it's before you. Mr. Webster appealed this, and in response to his petition for review, we asked the court to also take this issue. Now, I didn't cross-appeal or cross-petition on it because I felt like it was raised with specificity. The Court of Appeals did rule against me on that issue, and so that's why I asked for this court's review of it. I do agree with Your Honor that there is language in Judge Larkin's decision that I agree with, but ultimately the holding of the case is that it was a violation for Hennepin County to refuse to do Mr. Webster's term search.
The language with which you agree is dictum?
I don't know that it's dictum, Your Honor. It's hard to determine exactly what the language is telling Hennepin County to do, because it's asking us to do a search for one thing, to search for biometric data, and if we can craft a search that doesn't produce what we believe are not relevant responses to the request, then we can do so. I think if that's what the holding is, then I believe that the holding is improper, because ultimately, I think the legal question here, and the legal question that was before the ALJ, is whether or not a requester can determine the methodology and the location to compel a government entity to search for data. And I believe the answer to that is no, that is not a request for data. A request for data requires a request for something. They get to ask us the what, not the where and the how. And the Court of Appeals kind of said that was right, but then they said, but you have to do what he said anyways. And that's the part that I don't believe is correct.
But counsel, how is he requesting or in any way dictating the methodology? What he did was say, I'm looking for these terms, and if anything, it seems to me that would have made it easier for the county to comply. I don't see how that's a demand that you use a particular methodology. I suspect Mr. Webster doesn't care how you get the documents and what methodology you use.
So, Your Honor, the methodology involves, I think, two different parts. One is he told us where to look, and that's important because initially he told us to look at all 8,000 employees. We're required under 1301 subdivision 1 to arrange our data in a way so we know where it is. I know that 95 or 98% of the Hennepin County employees don't do anything at all with biometric data. They don't have any idea about it. They've never thought about it. They've never written an email about it. But his methodology required me to search for it in every single employee's email. And that's the part that I believe is he's telling me the where. He's also telling me exactly how to do it. He wants me to search for specific terms, even though those terms, I believe, in many cases, are not going to get to the what. He's looking for information about biometric data. One of the terms that he looked for was biometric. I happen to know that Hennepin County, in the time frame that he was asking for it, had biometric data related to all of our health care, that if we submitted biometric data for our own health care, that would, we'd get a premium change. So he's asking to search for specific terms in locations that I believe make it so that we have to do an unduly burdensome search to prove to him, not that we've found data that's responsive to his request, but to show him that there is no other possible data that's out there that could be
Counsel?
responsive.
So would that be akin to a fishing expedition?
Yes, Your Honor, I believe that I don't believe that's what Mr. Webster's intent was, but I believe when somebody asks, when they don't have the data, they don't know how we have stored it, when they try to control the methodology and the location, it ultimately ends up in a fishing expedition where we're trying to prove not the existence of the data or give the data that we have, but to prove that we don't have that data anywhere else.
Well, counsel, I don't know that I completely understand your argument. You know, let's take it outside of this context. If somebody gives the county a data request, and they say there's some really highly controversial zoning dispute, and the press wants to cover that zoning dispute. And so they say, a member of the press sends in a written request and says, I want all emails from Hennepin County employees on anything having to do with this zoning request, any internal emails. I think you're telling me that would not be valid because they're telling you where to find it, which is in your email system. That's what I heard you say, and I can't figure out how that situation is any different from this one, other than the one situation is maybe more burdensome than the other. Can you explain that to me?
Yes, Your Honor. I think the difference would be in that zoning request, the response would be, we will look in the employees' emails who are dealing with that issue, but you cannot require me to go look in other employees who are dealing with child protection issues just to prove to you that they don't have anything to do with the zoning request. What Mr. Webster request was all employees. If the request is, I want you to search in all employees, and I happen to know that only a certain number of them deal with that issue and that we store our email by employee, then it's up to me to search in those areas where the data exists, and it's not incumbent upon me to search in those places where the data doesn't exist.
So his original request was overbroad, but my understanding is he narrowed it considerably because the county told him it's overbroad. And so what's then wrong with the second request where he limited to security personnel and people who deal with biometrics?
So Your Honor, it continued to suffer from the same defect it had before, just less so. It initially had more than 8,000 employees. It got down to 868. And what we requested was, based on all of the information we have provided you, the 6-page response that we showed you about what data we have, what are you really looking for so that we can go into those email accounts or look in the places in the sheriff's office to find just what you're looking for, rather than having to do a global search for all 868 employees for the 20 separate terms that he requested. That was still too broad. We were asking him to narrow it more. We were trying to engage in an iterative process to try to get to a resolution where we could say, now you have reasonably described it and we can answer it. But before that could happen, he filed the OAH.
What if the requester isn't quite sure what he or she wants? And I used to be an academic, and sometimes I'd go into a set of data and I wouldn't even know what I want. I would just, you know, I would want to research a particular issue. And so it sounds to me like the nature of this particular request was I wanted everything on biometrics, but I'm not sure what the outcome's going to be. I'm open-minded on this, and I want to figure out how Hennepin County uses it so I can write something on that. I mean, how does your position accommodate sort of, and maybe you call it a fishing expedition. I don't necessarily think that's true. What do you do when somebody just wants to research a particular issue?
Well, there's two responses to that. First, they have to reasonably articulate what they're looking for. The Data Practices Act doesn't require us to do research. That's clear. But you're right, that oftentimes the requester won't know where the data is located, so they won't know how to articulate specifically in a way that might get to the data. And that's where there has to be an iterative process. But what you can't do is what Mr. Webster did, which was, I don't care that you're telling me that you don't have some of the data, that it's too broad. I still want you to search in places where you're telling me the data doesn't exist so that I can be certain that I've found every piece of email that mentions the word biometric. And I don't care if 90% of it is not going to be relevant to Hennepin County's use of facial recognition technology, which is the only technology that we used. It's forcing us to do something to prove a negative, and I think that's not what the Data Practices Act requires. It requires us to respond to reasonably articulated, reasonably described data requests.
Is there a problem with placing this I mean, the standard you're articulating, I think one of the problems I'm having with it is a requester makes a request, but you're arguing the county can sort of do what it wants. It can be the gatekeeper, and it can change the request, it can say, I don't really want to do that request. And the whole point of the Data Practices Act is transparency. And so it could end up having the perverse effect of allowing the fox to guard the hen house, so to speak. And so alleviate our concerns if you can about why it's appropriate to give that much discretion and that much power to the county itself.
Certainly. So I think there's two responses to that. One is if it is reasonably described, there are situations where you would say, I'm interested in communications between this set of people, and so I'm looking for communications from the sheriff related to this subject, which we may have to do a term search on, and that can be something that can be described. And so it shouldn't be left to only the county's role of saying, this is the only thing I'm going to do. It has to be a give and take, and it may be that we do produce some data, they look at that data and say, well, based on that, I want some additional data.
But counsel, isn't, I guess I'm troubled a little bit by the fact, and maybe this goes to the timeliness issue, but isn't that what Mr. Webster was asking for all along, was that give and take that you're talking about? I mean, the record, it seems to me, is replete with emails and letters from Mr. Webster saying, talk with me. If this is too broad, if this is, whatever your problems are, talk to me about it, let's work that out. So it seemed to me he understood that, maybe I started out with this broad universe, but I'm willing to look at how that might be narrowed and in order to work with the county. And the county this record seems to reflect, did not take him up on that until much, much later in the process.
So, Your Honor, I think there's 2 points there. You're right that we didn't do it until November 25th. So there's that, and that's were we reasonably prompt in responding to his request that we provide him something? And the answer to that is that it took a long time to answer the questions and the data practices requests that he had, and that's what our November 25th response was. But then from that point on, and the reason for that, as articulated by Ms. Lottie Johnson, was she wanted to provide him sufficient data in response to his request so that he could have information so that he could narrow it, so they wouldn't have to do what Justice Strauss had questioned, which was, I'm just going to trust you, that you know what I'm looking for, and so I'm going to capitulate to narrowing it in a way where I don't know. But further to Justice Strauss, your question about this trust question of how do you trust us, I think the answer to that, there's three, I think, specific answers to that. One is the act is predicated upon us following the law. It's predicated upon local government and the state following the Data Practices Act. Second, there are administrative, civil, and criminal penalties for violation of the law. If there's an intentional violation, there's criminal penalties. And third, this idea of the evil employee that, the county or the particular employee is going to try to come up with a method to avoid the transparency in the act, and they're willing to go to illicit means to do that. Even under Mr. Webster's term search process, that can still happen. An employee could refuse to do the term search or lie about the results of it.
Counsel?
So I think that sorry, Your Honor.
If you finish the trust point.
Yep.
Okay. I'd like to, in the time remaining, try to figure out what constitutes me demanding the way that you search. So let's say I'm interested in any documents in the county involving my name. Am I okay in limiting my request to emails, or have I thus directed you how to search? Can I say, I just want emails about Lillehaug?
Your Honor, I think yes, you could ask that.
Okay.
And then my response would be, I know that Justice Lillehaug has interacted with the county in these 3 different areas. He hasn't had any interaction with the sheriff's office, so I'm not compelled to go and search the 800 emails from the sheriff's office to see if Justice Lillehaug's name is in there.
So your position is that the county can evaluate my request and decide on its own the locations in which it's going to search, even though there might be somebody, say, in the assessor's office that's been emailing about me?
Yes, Your Honor. I think that the idea that the Data Practices Act requires us to prove a negative, which is to prove your point, which is of the 8,000 employees, is there anyone who we don't, in areas that Justice Lillehaug hasn't interacted with the county, is there anybody talking about Justice Lillehaug?
But counsel,
I don't think it has to, I don't think
doesn't
we have to
that
do
bring
that.
us right back to that trust point? And I agree strongly with Justice Strauss on that. And you know, maybe let me phrase it this way. What's your best argument? What in the Data Practices Act supports that position, that you can be the sort of gatekeeper of it? Because under your theory, Justice Lillehaug wouldn't find out about all of the emails that talk about him.
And while you're answering that, if you could also articulate, I mean, the Hennepin County is the keeper of the information, and you obviously know how information is kept. And does that play into the decision-making process as to where you look for the data?
Mr. Rogan, your time has expired, but please go ahead and answer those questions to the extent you can, and I might even have one more, so go ahead.
Certainly. So, Your Honor, I think that the answer to the argument for what's the best case for why we get to focus on where we're going to search is the Act requires a requester to make a reasonable description of what they're looking for. And I don't believe it's a reasonable description to say, I want you to search for data in every possible place, because a request always requires a search. Even if you ask for something very specific, I want you to find a contract. Somebody has to search for that. But the opposite, which is what I think that Mr. Webster's argument leads to, which is I want to find all of the data in the county, regardless of whether it's an email or in a database that contains the word Mississippi. I think that that's also a search. We could be compelled to do it. It's reasonably specific. We can probably find it, but it's going to take an unbelievable burden because we're going to have to read documents. We're going to have to do stuff that is not specific enough. So I believe that the answer to the question is the plain language of a request for public data requires a reasonable description. And I think even to the extent that there's some ambiguity about what that language means, I think the context of the act and the absurd result that would result if in fact it was that you got to control where to search and how to search leads to a more narrow construction that allows the government agency to respond to data practices requests by looking for data in the places where it is going to be found. That's actually how the FOIA, the Federal Freedom of Information Act, works. And what the courts there have said is that if it's not reasonably described, you don't have to respond to it. And it's not a reasonable description if it requires an undue burden to search for it. And it's for this very reason that it's hard to articulate when you're talking about the Justice Lillehaug name.
Into this whole issue that comes up in the briefs too about what part of the act provides for undue burden as an affirmative defense, if you will, for lack of a better word. But I know you've got several questions going here, so I apologize.
Can I answer Justice McKay?
Please do, yes.
Justice McKay, you're correct that I believe that the reason that I have to go look in certain places is because I'm the keeper of the data. The county's the keeper of the data. They know where the data is kept. When somebody asks for a police report, I know to go to the sheriff's office. I know to use their case management system to find it. I'm not compelled to go look anywhere else for it because I know where that data is kept. Email's the same way. It's a communication tool. I know that if I'm looking for emails about a particular subject, the way that we store our data, which is I think the way that everybody stores their email, is by person. So I'm going to have to figure out who are the people or what's the department that has been dealing with that issue, and that's where I'm going to have to go locate that data. But that's up to me, as the Court of Appeals said. They can't control the search methodology The requester cannot control the search methodology or the location. That's up to me because I know where the data is kept.
I have one more question that is, I think, much simpler than what we've been talking about here, and that is, I think we've established that the issue of timeliness is not before us. Your opposing counsel suggests that the issue of any issues with the redaction is also not before us. Is that correct?
That's correct, Your Honor.
That's all I have. Thank you.
Thank you, Your Honor.
Thank you, Mr. Rogan. Mr. Flaherty, you have 15 minutes for rebuttal. And I know you're anxious to get at responding to Mr. Rogan's argument, but before we do that, I do want to touch on a topic that we did not discuss when you were with us previously, and that's the arrangement of the data. And let me tell you what, I have a little bit of a problem with your argument here, because your brief goes on in great detail about the various failings of the county. And it really seems to me to be more about the absence of procedures or execution of the procedures. It doesn't seem to be about the arrangement of the data. And in fact, in several places, I think you suggest that you agree that the county has state-of-the-art servers, they have the necessary equipment, they could easily respond to the requests. They don't. Doesn't seem to have, in other words, the evidence of issues with the arrangement of the data, other than the conclusory statement by the ALJ, doesn't seem to be there. Tell me why I'm wrong about that.
Two reasons, Your Honor. One from the ALJ's decision and one from a relevant iPad opinion. The ALJ correctly determined that the fact that Hennepin County raised the issue of burden in responding to this request showed that its record-keeping arrangement was not easily accessible for convenient use. That's in 1303 subdivision 1. So again, like with the procedures, the test for whether an arrangement is adequate under Chapter 13 is a functional one. We can't look at an Exchange email server in a vacuum and say, because this is state-of-the-art, it is per se an adequate arrangement. An arrangement only complies with the statute if it is easily accessible for convenient use. And so the record here revealed that Hennepin County's employees who were involved in this process didn't know how to use the technology that they had purchased. And that's a problem. If the iPad opinion I'm referring
But that's my problem with the argument. It seems to me that's about procedures. It's not about the arrangement of the data. The data's all lined up, marching off in ones and twos like it's supposed to. They just aren't using it correctly. Isn't that what we've got here?
I disagree, Your Honor. The statute uses the phrase, arrangement and condition as to make them easily accessible for convenient use. So whether the arrangement is good is a functional one. If Hennepin couldn't access their data easily for convenient use, the arrangement is bad. Now maybe that is also evidence of a procedural violation, and subdivision 1 and 2 are related in that way. The statute should be read as a whole. But if a county purchases technology it can't use, that arrangement is not proper.
Well, but my understanding, just to follow up on that exact point, my understanding is that they use the Microsoft Exchange server, and there's some information in the record, some exhibits in the record that show that used correctly, this Exchange server could have yielded all the data that you wanted. It just so happens that they didn't know how to use the data correctly. And again, doesn't that get, at Justice Anderson's point, this is sort of one of the reasons for using an Exchange server. So why is it not arranged in a way that would allow the requirements of the Act to be met?
Because Hennepin's use of Exchange did not make the records easily accessible for convenient use. That's not disputed. These records were, Hennepin believed wrongly, it turns out, that it was going to take them 10,000 hours to get these emails. Now, the ALJ later determined, after hearing a full factual record, it would only take 18 hours. But the state-of-the-art Exchange server is not appropriate for an entity that doesn't know how to use it. It's no different than the jammed copy machine in one of the iPad opinions.
But it would be adequate if you did know how to use it.
Correct. So,
Okay.
again, the test in the statute in subdivision 1 is functional. The question is, does the arrangement make the records easily accessible for convenient use? And where a county knows how to use technology, that arrangement is proper. But if a county purchases technology it can't use, that is not a proper arrangement. It's a functional test, not one that can be evaluated in a vacuum. It truly is fact-specific, and it's going to vary county by county. It isn't simply a bright-line rule that if you buy a state-of-the-art email server as an entity, that's per se compliance. That example, as this case reflects, may not lead to easy accessibility of government data. And if so, the arrangement's improper.
Counsel,
violates
how
subdivision
do you
law.
respond to the county's argument in that you're asking them to essentially prove a negative by dictating the where and the how in the search terms?
That response by the county both misreads the request Webster actually made, as well as the ALJ's finding regarding that. The ALJ found that Webster's the language describing the search in Webster's request item 14 was done to help the county comply with his request. Now, his request was very precise and specific. He sought government data containing specific keywords. He could not have been more unambiguous about it. Both the ALJ and the Court of Appeals kind of correctly recognized this too. The ALJ never ordered Hennepin to conduct a search. The order in the ALJ's memorandum is for Hennepin County to produce the data Webster requested. How it produces that and where it searches always remain with the county. So we agree that there appears to be no legal dispute that a requester can't demand a search, but what a requester can do is what Webster did here, and identify data specifically, and then he's entitled to do it. The county doesn't have the obligation that Mr. Rogan referred to prove a negative to Webster. The county doesn't have to prove anything. Its obligation under the act is almost singular. Produce the data. Comply with the request. That is what subdivision 2 requires. That's all.
Counsel, I just have a question about when Webster narrowed his request. Was that voluntary?
Yes, Your Honor.
So what we're dealing with here is not the original request. When it goes back, if it goes back, it will be that narrowed request.
I don't disagree with I don't agree with the second question, Your Honor. When they didn't resolve his outstanding requests after he voluntarily narrowed it, when the action was commenced in the OAH, it sought an order compelling compliance with the August 12th request, and the ALJ's order finding Webster as the prevailing party compelled the data in response to that request. So what the record shows that Webster voluntarily narrowed his request in hoping to avoid litigation, and that was not successful. And so at the conclusion of the OAH proceeding, he received an order compelling production of data identified in the August 12th request. That's what he asked for, and that's what he got.
Counsel, let me see if there's any limit on your proposition on what the government must produce. Let's say that I just decide I have all the time in the world, and I just want to browse all the emails that were generated by Hennepin County in the year 2016. Does Hennepin County have an obligation to provide me access to all the emails that were generated in 2016, which may be millions upon millions?
Yes, Your Honor. Yes, almost unqualifiedly.
Almost unqualifiedly?
Almost. And I have to acknowledge the existence of a few iPad opinions that seem to recognize a sham request exception, that where a requester is subjectively intending to abuse the government, it may stop responding after some initial compliance. That rule doesn't have a basis in the text of the statute, but it does in the iPad opinions, which are entitled to some deference. But even that opinion contemplates initial compliance by the governmental entity, and then the requester needs to not show up to kind of signify that this is a sham
So I
request.
can request to inspect, as long as I'm not asking to copy, in which case then I can be charged with the cost. But if I just want to inspect, they've got to assemble in some way all the emails from the year 2016 so I can browse them at my leisure.
That is correct, Your Honor. And in fact, both the statute and the iPad opinions contemplate that a governmental entity needs to, ahead of time, before receiving a request, know what it collects, how that data is classified, and to whom it can be disseminated. Those are phrases from an iPad opinion from 1994 that was to Hennepin County itself.
So if there are going to be any limitations on the scope of my request or the burden the county has to undertake to allow me to inspect, it sounds like it's the legislature's issue.
Yes, and in fact, this afternoon, the legislature is holding a hearing on the Data Practices Act at 2 o'clock, and Webster is expected to testify. So the county has concerns, not illegitimate concerns about burden, but we do take issue with the implicit suggestion in some of the arguments that the MGDPA is an appendage to normal government operations, or is somehow supplemental or optional or less important than the government's other duties. In enacting Chapter 13, the legislature engaged in a policy choice to hold that the MGDPA matters and its compliance matters. Compliance with it matters. The iPad one IPAD opinion uses the phrase that compliance with the MGDPA is county business, and that's true. So unless and until the law changes, a requester may review all emails sent or received in calendar year 2016. That should actually be a very easy request to comply with if the rest of the portions of the statute are met. If an entity is classifying its data ahead of time, knows where data is stored, it should take the county very, very little time to produce that first email.
Counsel, maybe they can quickly assemble all the emails from 2016. I have some doubts about that, but then they're going to have to screen all of them to determine what's public data and what's private data. I mean, am I wrong about that?
You're wrong about both, respectfully, Your Honor. The Act does not require them to...
Double wrong.
So on the first point, the Act does not require an entity to complete production promptly. It has to begin promptly. It may take a very long time to go through all of the emails from 2016. It should not take a very long time to produce the first little bit.
Start producing some emails from 2016.
You know, the journey of 1,000 miles begins with a single step. It's not, this isn't a case about how long it took Hennepin to complete compliance with this request. It's about how long it took it to begin. The first bit of data here was not produced until
Okay, so
December.
I'm wrong about the first one. How about the second?
Both the statute and the relevant IPAD opinions instruct a county to know ahead of time to whom its data can be disseminated, whether it's public or confidential. That's IPAD opinion 94058. So before a request comes in, if an entity is complying with the MGDPA, it needs to already know what is public and not public and where its information is stored. If it has to figure that out after a request comes in, according to the IPAD opinions, it's already violated Chapter 13.
The Act doesn't require that every time a piece of data is generated that it at that time be classified as public or non-public.
The IPAD opinions seem to suggest require a proactive
That's
approach.
just great that IPAD has decided that somebody's supposed to do that, but where in the statute does it say that?
The statute does not, we acknowledge the statute does not have that level of
So
specificity.
IPAD just made this up?
It did, and that goes to another policy decision the legislature made, which was requiring IPAD opinions to be given deference by courts. And so that deference perhaps has limits, and we're not suggesting IPAD opinions
Yeah,
are...
that's not litigated in this case. I have some serious doubts about that, whether we can be instructed to give deference to an administrative agency opinion that doesn't seem based on the statute.
We did not seek review of that issue.
I understand.
So as I understand it, your argument is that when you look at subdivision 2A, there's the language about the request must be complied with in an appropriate and prompt manner. And so you're rejecting that the appropriate gives the county any discretion about which emails to provide.
I want to answer the question, but I think there's some lack of clarity I'm having with it. I don't believe the county can withhold, I don't think the word appropriate allows a county to withhold responsive data. That is not part of the word appropriate. But I do think one thing built into the word appropriate there goes to a point I was discussing with Justice Lillehog about how long will completion of the task take. So appropriate does some work there, but it doesn't, the notion of burden is not in there at all. And in fact, as the ALJ properly recognized, claims of burden suggests that the record arrangement under subdivision 1 is not adequate. So the appropriate modifies both receipt and compliance. If there are no further questions, we would ask that this court affirm the ALJ's ruling in its entirety and reverse the Court of Appeals in part. Thank you.
Thank you, Mr. Flaherty. My thanks to both counsel for their help in arguing this case and providing assistance to the court as we decide these issues. The matter has been submitted and will be decided in due course.